the act requires is that the public have access and that the public be allowed to come and hear what their elected officials are talking about and what decisions are being made. But there's no specific requirement in the act that the public be allowed to comment unless certain statutes require public hearings. So, I mean, you can all think of examples of what those are in the statute that requires a public hearing. If there's a public hearing required, then yes, that's something the public by statute has a right to come and comment on and give input to the elected officials. But just your general, everything else that's on your agenda or even things that aren't, there's no right set out in the act for that. So you have to make a decision up front. Are you going to allow public comment or not, except for public hearings? And there are a few governing bodies in Texas that have decided not to allow any public comment at all. The public is welcome to come in, they're welcome to listen to what's going on, hear the deliberations, but no public comment is allowed. You know, that's a policy decision for each of you individually to make. It's probably, if you were to decide, and some of you may already have this policy, but I'll just say in the abstract, if a governing body was to decide not to give the public any opportunity to comment, that's probably not going to be viewed very favorably by the public because people kind of expect that. But assuming you do decide that you're going to allow public comment, what most folks have, and what's a good idea, is most governing bodies adopt some sort of rules of decorum, limits on how long public comment is going to be by a particular speaker, or sometimes even on a particular topic. I know especially in some larger cities or counties, there's even rules that I don't think they necessarily require, but they encourage folks. If you've got 50 people who are all coming to the Commissioners Court meeting and want to address the commission about an issue, they encourage folks, pick up 1 or 2 spokespeople to speak on behalf of the group instead of having everybody come up one after the other and say the same thing, or come up, as I've seen before, and say, "Hi, my name is Brad Young, and I just want to say I agree with everything the speaker before me said." So you can come up with and enforce your own rules for how that's going to work. And the other thing that you can come up with and enforce, and you'll see this if you kind of Google other people's rules of decorum, is you can actually require decorum. You can require that people be civil to each other, that there be no disparagement of the governing body or of specific individuals, and whoever the presiding officer is at your meeting, that person has the right to enforce those rules, to enforce the time limits, and to enforce the decorum and say, "I'm sorry, but our rules don't allow for disparaging comments, and can you please conclude without making any more comments like that?" And if the individual who's speaking is not willing to comply with that, then they can be asked to step aside and let the next speaker come up. And usually people are pretty good about abiding by that. One thing that I know I've seen in some cities and counties do that have these rules is maybe right before the meeting starts, sometimes there'll be, like, the city secretary will come up and sort of welcome everybody, point out where the restrooms are, where the water fountain is, and then mention the rules of decorum and either refer to them and ask the comments be kept civil, or even, I've even seen some cities where at every meeting the city secretary actually reads out loud the rules of decorum prior to the meeting. So that way, everybody who's there kind of has in mind before the meeting starts what the rules are, what's to be expected. The comments are welcome, but that it's expected that you're going to behave and you're going to address your comments in a civil and constructive manner. Not really an Open Meetings Act issue, just a couple of bullet points there that are worth mentioning. You know, the Federal American with Disabilities Act also governs your public meetings. So you need to be able to provide access for people with disabilities, hearing impaired persons that want to come and attend the meeting. You may be required to provide an interpreter upon request. What a lot of folks do, what some of you may do, is you may have an ADA notice at the end of your agenda and say, please contact the county or the district or the city within 24 hours prior to the meeting if you need an interpreter, just to kind of give you a heads up, a little lead time if you need to find somebody. And I think I said this, but let me just say again to make sure it's clear. The talk about public comment and with how that's optional, whether you allow that, that's not the case for public hearings when those are required. You have to allow the public to speak during public hearings, but you can still impose your rules of decorum on the commenters on public hearings, just like you would during normal public comment. Let's talk about the 3 different types of meetings that are recognized under the Act. So you have your regularly scheduled meetings, usually depending on what your statute says or what the elected officials decide. Usually those are once or twice a month on second and fourth Thursdays or whatever you decide they are. You have your special or called meetings, and the statute, your enabling statute will set out how you can call those. And then you have your emergency meetings. Let's go back and talk about some of the differences between those 3 meetings. Special meetings and regular meetings are conducted the same way. You still need to have the 72 hours advance notice posted in accordance with the Open Meetings Act. Basically, the only difference between the 2 is regular is just what it sounds like. It's the time that's regularly scheduled, but it doesn't. So the public knows exactly when that's going to happen. Special meetings are ones that are called sometime other than your regular meeting time, but still they'll have the 72 hours advance notice, so the public still knows when that meeting's going to happen. And then there's emergency meetings. And where there's sometimes a little bit of confusion is what constitutes an emergency meeting. An emergency meeting, what the legislature has said and what the Attorney General has said in construing when an emergency meeting is important, is it has to be a true emergency. It's not enough that, where I've seen folks before, what to have an emergency meeting is, you're involved in some lawsuit and you just got a ruling from the judge and it's pretty fresh, you know it's going to be in the newspaper, and all the elected officials want to have a chance to talk about it. That's valid. Of course, you want to have a chance to talk about it, but just getting a ruling from the judge is not the type of emergency that's contemplated in the Act. You still need to do the 72 hours notice if it's something like that. For an emergency, it needs to be a true emergency, like there's been a natural disaster, and if you don't get together and meet within less than 72 hours, then there's going to be the public catastrophe, or whatever it is, it's going to get worse. Some of you, I mean, you probably read back about this time last year, around Memorial Day in the Central Texas region, there was some really pretty horrific flooding in Hays County and Travis County. And I know a lot of the cities in the county at that point were calling emergency meetings because there needed to be immediate disaster declarations in order to release some of that state and federal money and let people come in and start helping some of those folks who've been decimated by those floods. An earthquake, a tornado like they had around Cleveland a few years ago. Those are the types of things that are emergencies under the Act. Anything less than a natural disaster and pretty much total devastation of your community, you need to wait the 72 hours because it's not going to be an emergency. And the reason that the category of what's an emergency is such I guess, a narrow definition is because unlike regular or special meetings, emergency meetings don't have to have the 72 hours notice. They just have to have a couple of hours. If the media may be entitled to, if on request, the media may be entitled to getting a fax or a telephone call notice if that meeting's about to happen for an emergency. But there's very specific requirements that you have to go through to call an emergency meeting. You want to work with your legal counsel whenever you do that. And hopefully those meetings are going to come up never or maybe once or twice in the whole time that you're serving on the public board. They're just something that shouldn't occur with any frequency at all. It only should occur in the case of a true emergency. Let's walk through a little bit about the way a meeting works. Meeting cannot begin until a quorum is present. One question I get sometimes, both from clients and when I do these trainings, is, well, what happens if a quorum doesn't show up? What happens if a quorum requires, say, 3 commissioners and only 2 show up for the meeting. Does anybody know what the answer to that is? Yeah, it's not a meeting. Those 2 commissioners can talk about whatever they want to, but they can't take any final action. It's not going to be a deliberation within the act. It's not going to be a public meeting. So you'll have to reschedule the meeting for some other time if there's any action that needs to be taken. The meeting also can't begin until the exact time that it says on the notice. So what all of you probably experienced before is if your notice says that your meeting's going to start at 6 o'clock and all the members of the public and all of your commissioners or board members are up on the dais and it's 5:59, and you all just kind of sit there and smile at each other until the clock turns on to 6 o'clock, because you have to wait until it's actually the time on the notice that it says for the meeting to start. Committee meetings. A lot of you, probably all of you, may appoint committees, either of members of the community or maybe subcommittees of the Commissioners Court or your city council or school board, to meet in smaller groups and talk about issues that are going to be brought back before the governing body. A lot of cities have planning and zoning commissions. You may have, if you're counting, some sort of emergency management committee where you appointed members of the community to talk about, make plans and recommendations for what to do in case of an emergency. Generally, those committees are not going to have any final power to bind the county or the district. And so there's sometimes some debate about, well, do those meetings need to be posted as public meetings or not? And the better practice, and the practice that the Attorney General has recommended, is that go ahead and post your committee meetings. Even if those committees are purely advisory committees, go ahead and post them anyway. Because the rationale that the Attorney General has given for that is, you want your committees to meet, you want them to give valuable input that can later be acted upon by the governing body. And so if the real deliberation about the nuts and bolts about how we're going to address this specific issue that's facing the county or the school board or the city, if the nuts and bolts are going to be discussed at the committee level, then you want the public to know about that and have a chance to come and hear those discussions and participate in those discussions. And especially if the governing body, if it's a committee you really trust, or they just come up with a great recommendation and you don't feel the need to deliberate, and you just kind of vote and rubber stamp. That's what the Attorney General, the phraseology he uses, that you just rubber stamp what the committee does, then the public will have missed out on the chance to actually hear the real deliberation if they didn't have an opportunity to come and hear the committee deliberation. So the best practice is go ahead and treat those committee meetings just like you treat meetings of the rest of the governing body, of the main governing body, just so there's not a question later as to whether you have that supposed rubber stamp issue. Another one that comes up is workshop meetings. A lot of y'all probably have those either as separate meetings or as a particular portion on your agenda. And in some places out there, and I'll tell you now that there's attorneys who differ on this too. There is one school of thought that workshop meetings, because what most people generally consider a workshop means no final action will be taken, it's just discussion. There's one school of thought that says workshop meetings don't necessarily have to be posted under the Open Meetings Act because no final action would be taken. I'm not of that school of thought. I think, again, the better practice is, even if it's a workshop meeting, even if you know no action is going to be taken, go ahead and post it anyway, because again, it's kind of the same rationale as with that committee discussion we were just having. If the real deliberation among the governing body is going to happen at the workshop, and you're just going to vote later after you vetted it out at the workshop, the legislature and the act contemplates that you're going to give the public the chance to come and hear that actual deliberation, even if it's at a separate meeting, so they know what it is the commissioners or the council members or whoever it is have talked about once they actually come to the meeting. So I would go ahead and post those as well.
Are you saying you can't take action at a workshop if the meeting's posted?
You can, as long as it's posted that way. And one thing to remember about workshop meetings is that is not a term that's defined in the Open Meetings Act. You're not going to find that anywhere in the Act. And so different people define workshop different ways. some commissioners' courts may consider a workshop something where we're gonna talk about it and vote at the end. And some commissioners' courts may consider a workshop something we're only gonna talk, but then we'll vote at a separate meeting. So it just depends on how you locally define that, and that's another reason, because the public may not know from body to body how each particular body defines it. That's another reason, just go ahead and post it anyway. Yes, ma'am.
We've been told by attorneys that kind of do that for DSD, that the public, they can come to the workshop meeting, they cannot participate, that we don't get input from them on anything. Is that true?
That goes back
We
to,
don't take action on anything, that we just talk among ourselves. And the public can't come in there and say, well, we want you to do this or that at the workshop meeting.
that goes back to when I was talking about public participation in the rules of decorum. There's no requirement under the act that you let the public come and participate during a workshop or during any other meeting unless it's something that requires a public hearing. So you don't have to let the public come to those workshop meetings and make comments.
We couldn't, we've been told that we couldn't allow the public to talk at the workshop meetings.
I'm gonna defer to your attorney on the particular facts of that case, but I'll speak generally, that that depends on the rules that you as the board have adopted. Now, I'll tell you another one, I think is another best practice. This is not really an open meetings issue, but more kind of a Robert's Rules of Order type issue, is for any kind of deliberation, especially depending on how many folks you have at your meeting, just to sort of keep order, a lot of times it's helpful, and sometimes you may have this spelled out in your rules, to have, say for a particular agenda item, workshop or non-workshop, give the public the chance to come and comment first, make whatever comments they want, close the public comments section, and then have the deliberation just among the officials on the dais. And then the public can still hear it, and you may decide, the presiding officer may decide to open back up the public comment during that agenda item. But sort of from a practical standpoint, especially if you have a whole lot of people in the room, it does get kind of hard to deliberate if instead of just 5 or 6 elected officials, you have 50 people that are all trying to deliberate at once. So just sort of how you run the meeting, it kind of makes sense to do it that way. But that's just a local choice that folks can make as far as how they want to run their meetings. Social functions. I think most of you probably already know this, but I'll go ahead and point it out. The Open Meetings Act does not require that you post notice and follow all the procedural requirements. If the function is purely a social function or a ceremonial event or a training in which no final action is going to be taken, and any discussion of public topics is merely incidental. So if you're having a groundbreaking for a new business and all the members of the commissioner's court or all the members of the school board for a new school are going to be there, it's still a good practice, and most people will do, a lot of people do this, to go ahead and post that anyway and put on your agenda that no official action will be taken. But if everybody just happens to, if all the elected officials in a particular body just happen to show up at that meeting, that's not a violation of the act for those types of ceremonial events. Same thing with the trainings that you go to, whether it's the VG Young or the Texas, what's the county one called? TAC. Yeah, a TAC or a TML training that you may go to, where you're going to, as elected officials, you may all be there together going to trainings on the types of topics in general that you're going to face on your board. Just going to those trainings, that's not prohibited under the act. The legislature understood that it's a good thing for folks to go to those trainings. You may not be able to anticipate everything that the speakers are going to talk about. Still, you want to be careful that in between the breaks, that you don't all stand around with your other elected officials and deliberate whatever it is that's affecting you locally that the speaker was talking about. But just being there, asking questions, and other folks who are attending the seminar hearing your questions, that in and of itself is not a violation of the act. talk about the mechanics of agenda posting. What's required for your agenda? Different people do agendas a little differently, but some of the basics, what's required by the act, is your agenda has to have the date, hour, place, and subject of any meeting, and it has to be posted at least 72 hours in advance. The one exception that we've kind of already touched on is your emergency meetings. You also have to have a notice there, but they can be only 2 hours in advance. You have to define what the emergency is, and it needs to be basically imminent threat to public health or safety, clearly identified in the notice. Has to be sent to the media by telephone, facsimile, or email, and that's at the request of the media. So like what a lot of newspapers will do is they'll just sort of have a standing request with whatever the governmental body is, which says, if you post an emergency meeting in the future, please send us the notice under the act, and then you kind of have that on file and notice in the notice to the media. And you have to have at least 2 hours in advance. There is, under the act, you are allowed to recess a meeting until the following business day. So this doesn't happen real often, but sometimes if you have a really full agenda or and the meeting starts to run late, people do use this sometimes. If you get to a certain hour when you and your fellow elected officials just think, I'm too tired, I need to go to bed, I can't possibly think about another issue and be able to vote on it properly, is there a possibility we can recess this meeting? The act does allow you to one recess, you can recess the meeting until the next business day. Any subsequent recesses, you need a new posting, so you'll need another 72 hours. But if it's 11 o'clock on a Thursday night and you need to recess until the next day, for whatever reason, the act allows you to do that without reposting it. And I think the idea there is anybody who's interested in that topic is probably going to be at that meeting anyway, or watching it online if it's online. So they'll have notice just from hearing it talked about that's going to be recessed until the next day. I don't see that used a lot, but it's used sometimes, and the act does allow you to do that. And again, it's the next business day, so if it's a Friday and the next Monday is not a holiday, you can recess until Monday. One issue that we see a lot when the Open Meetings Act gets litigated is how specific does the notice have to be to describe what it is that's going to be discussed. And the general rule, what the courts have said, is that the subject of the notice has to be specific enough so that the public has a general understanding of what's going to be discussed. But it doesn't have to be so specific that it states all the possible outcomes that can come from that discussion. So there's a couple of examples up there of cases where this comes up. I mean, one that I can think of in a couple of cases is, say you're thinking about buying, the county's thinking about buying a particular piece of property. And you're past the point, we'll talk about executive sessions in a little bit here, but you're past the point where it's now generally public knowledge what the property is. Well, is it enough to say buy the property on Main Street, or does it have to have a legal meets and bounds description of what the property is? And there's been litigation over whether in an issue involving a piece of property where it has to be the legal description. The court has said no. That general description, the property on Main Street that's being considered, that's specific enough that the public generally, if they're interested, knows that's generally what's going to be discussed. You don't want to be you can't be so general that the public has no idea what you're going to talk about. So you can't just say, agenda item number 5, discuss property, because that's going to be too general. But as long as there's some reasonable description, the public has a general idea of what the description is going to be, of what the discussion is going to be, then that's allowable under the act. One court, the Austin Court of Appeals, described it as the notice has to at least give the public an inkling of the meeting substance. Another thing is you don't have to give the public, say you're discussing a contract, you don't have to put all the terms of the contract or all the terms that the the council or the court may or may not decide to adopt in your agenda. But you do need to identify the contract with a sufficient description so the public knows generally what contract you're talking about. And you may do that by saying, discuss contract with Waste Management, or discuss contract with X contractor, just so the public has a general idea of what's going to be discussed. What about the place of posting? The general rule that applies to everybody, this is one of those areas where it may be different depending on the type of political subdivision you come from. Generally, it needs to be posted in a place that's readily accessible to the public, can be read at all times of day or night. What a lot of people will do is they'll, on the front door, if it's a glass door like you have right there, you'll post the agenda backwards on the door so that if anybody walks up after business hours, they can look at the agenda and see what it says. County specifically, you're supposed to post your notice on a bulletin board at a place convenient to the public in the county courthouse, plus on the internet if you have a website. And is there anybody here who doesn't have a website for your political subdivision? Okay, if you don't have a website, then you don't have to create one just for the posting requirement. But if you do have a website, you're supposed to go ahead and post your notices on your website at the same time that they're physically posted in whatever place you physically post them.
Do we have to post them anywhere else other than the county? The county requires us to pay them $5 and they do the postal for us, and that's in the law. Do we have to post it, we always post it at City Hall in Glendale, and also with, of course, at our fire station, we have our meeting. Do we have to do that at City Hall?
I am not primarily an ESD lawyer, so I'm not super familiar with your statute. But if the statute specifically says the county,
Responsible for posting it.
right, it specifically says that, and probably specifically, generally it'll say a readily accessible place, so having it at the fire hall will count for that. If City Hall is not also called out in the statute, then you probably don't have to. I mean, generally a rule of thumb is the more notice, the better, just because, but I don't, without looking at the statute, just for what you're saying, doesn't sound like you have to, it's probably a good idea.
Our business, we're a small town, away from town, but it's posted at, the county posted for, nobody from that district probably ever goes down and sees that posted. And if we didn't post it somewhere else, nobody would even know what's happening.
And that is another one of those cases where the legislature's intention to make things public by telling you exactly what you have to do doesn't really fit with the reality of what's actually gonna make government more open to your constituents, but you gotta follow what the legislature has said. School district, you have to post on a bulletin board at the administrative office and internet posting if you have a website. Okay, what about official actions that you take? Let me back up a minute. I'm not sure if I've talked about agenda packets. All of you probably get agenda packets before your council meetings or before your commissioners court meetings or your public meetings that have the agenda and then back up with contracts or staff reports or whatever to help you get ready for the meeting. And that is perfectly allowable under the Act. I think it makes government more efficient. I think it's important to the extent you can to make not just the agenda, but those agenda packets available to members of the public if that's feasible to do. But there is not a problem with staff sending you agenda packets ahead of time. Again, the problems are the sort of email communications, daisy chain back and forth that we talked about earlier. But just sending the agenda packets, I think it's a good government practice, and that's allowable under the Act. As you probably all know, a final action or decision on any item that's in front of you cannot happen until, can only happen in open session, and final actions can only happen in compliance